Okay, we're now currently live. Mr. Florio, would you waive my reading my normal spiel to your client?
Yes, sir, Your Honor. We do waive that.
Okay. Mr. Ellis, sir, you're charged with one count of violation of Georgia Controlled Substance Act, and it's felony possession of MDMA, one count of possession of a firearm during a felony, one count of loitering or prowling, which is a misdemeanor, one count of possession of firearm by a convicted felon, and one count of also violating Georgia's Controlled Substance Act with the allegation is that you're in possession of more than an ounce of marijuana. Anything over an ounce is considered a felony. Because it appears that you may be on probation or parole, I cannot set bond at this hearing pursuant to Georgia statute 17-10-1 on the felony offenses. So bond is going to be denied on the violation of Georgia Controlled Substance Act, possession of a weapon during the commission of a crime. Loitering or prowling is a misdemeanor. There's going to be $1,000 bond set on that. I can't set bond on the possession of firearm by a convicted felon, and I can't set bond on the possession of marijuana over an ounce. You're going to have a preliminary hearing date set for January 4th at 8:30 in the morning. You're also going to have a bond hearing date set for January 6th. Now, Mr. Florio will be able to discuss with you the options as you move forward. Just because I cannot set bond today, it doesn't mean that bond will not be set, but it's just something that I can't do pursuant to law. Do you have any questions for me, Mr. Florio?
Judge, I spoke with Mr. Ellis's family last night and told them that I suspected, because Mr. Ellis is on first offender probation with Judge Scott, that bond would be denied this morning. Having said that, Mr. Ellis, I'll reach out to the district attorney's office this afternoon to begin the process of trying to work a consent bond out as quickly as possible. And I'll come see you this evening to explain what that looks like and trying to have you home for the holidays.
Okay. You're free to go back, Mr. Ellis. Can we bring up Mr. Borley? Borley, B-O-R-L-I-E. Mr. Borley, you're back here again today. Apparently, yesterday afternoon, detectives from Morrow Police Department obtained 4 additional warrants for your arrest. This was obtained sometime late in the evening. I wanted to have a discussion with Mr. Florio in your presence about your case. So, Mr. Florio, right now I'm inclined to deny bond based upon these additional charges, but I will hear from you, sir.
Judge, I understand what the new allegations are against us, but so with relation to what was found in the safe, I believe, from having spoken with his family, that genuinely is this man's life savings. And I truly believe that that's his life savings. As we discussed yesterday with the honorable court, he's self-employed. He's a hardworking man. And so essentially the cash that was found and what was found in the safe obviously is representative of savings, silver, jewelry, Rolex watch, cash. That's representative of things that this man holds close to him. and is an accumulation of savings, and that's what it is. It's not the proceeds of illegal activities or anything of that nature. With respect to the devices that were found, I've been told, and obviously I don't have proof of that for the honorable court this morning, but I've been told that what was confiscated yesterday would not detonate. There was no ability to detonate those, that they were artifacts and relics. I understand that there's an allegation that he essentially blew something up. If you take that allegation to be true, then we would have to agree that there's been no additional allegation of anyone's property having been destroyed or damaged. So there's not an allegation that he used a device to damage someone's home or their car. The allegation, and I use this term not to be derogatory, and I don't mean it to be offensive, but the allegation is you've got a redneck blowing something up in his yard. And one of those, hey, look at this. Watch this. And that's essentially the allegation, is that he blew something up in his yard under the, hey, watch this. And I know there may be a second allegation of something having been detonated in the middle of the street, but it's literally a knucklehead saying, hey, watch this. There's not going to be an allegation that he's made threats towards anyone. We know that because he's not charged with it. There's not an allegation that any person was injured. We know that because he's not charged with it. There's not an allegation that anyone's property was damaged. We know that because he's not charged with it. There's an allegation of him saying, hey guys, watch this, and being a knucklehead and blowing something up in his backyard. And then acting the same knucklehead and doing it in the street. Certainly it's unwise, but there's no additional proof of anything other than that boneheaded phrase that a lot of folks say, hey, watch this, and then regret what happened after the, hey, watch this. I understand the court's concerns. I believe to the extent that law enforcement was concerned about devices having been found at his home, those devices obviously have all been removed. If this honorable court were to grant bond this morning, obviously we would go home. We would not possess any devices. There's none at his house. With a hard lesson learned that it may have seemed like a good idea. It may have seemed cool. It may have seemed funny to do this. But it probably was unwise. It obviously alarmed his neighbors and alarmed law enforcement. And I understand that. I understand why they would be alarmed, but I don't think that there's any proof of anything other than this knucklehead saying, hey, watch this. We would ask that bond be set, with law enforcement having seized what they seized yesterday in terms of proceeds in the safe. This man that was his life savings, and we're not independently wealthy. He's a hardworking man, as we discussed yesterday, that is self-employed and works for himself. We would ask that bond be set, and that we would leave it in the discretion of the court as to what the court felt was an appropriate bond, if your honor's inclined to set bond.
How would you respond to the 12 ounces of marijuana that were found?
So, Judge, I represented a client out in Newton County recently, and he was a 71-year-old retired veteran. And law enforcement found a substantial amount of marijuana at his house. And he looked at me and he said, I'm 71 years old. He said, I can't be in the streets buying marijuana. He's like, so I get marijuana and I sit at home and I smoke marijuana because I can't be in the streets. And so the quantity of marijuana that they found at his house was candidly more than they found at Mr. Borley's house. But that was the reason for the larger amount of marijuana, was because he bought it in a larger quantity and sat at home and smoked it. Because being in the streets is not safe. You're a target of being robbed, and you're a target of other things that happen. I think it's interesting that the Clay County Narcotics Unit, to my knowledge, was not involved in this raid or in this seizure. And certainly I have lots of cases with them where there are well-trained narcotics detectives that are involved in a lot of these cases. Detective Denard, Detective Sobajon, and obviously I don't see them involved in this case, which would lead me to believe that he was not on narcotics radar for any allegation that he was distributing marijuana. And I don't believe he was distributing marijuana. I don't believe that there were drug-related objects consistent with drug sales located at his home. Obviously, I don't have the benefit of discovery, and if I'm wrong, Your Honor, I'm wrong. I'm not making a purposeful misrepresentation to the court. I just don't have any proof of that before me. I don't believe he's a drug dealer. I truly don't. Yes, sir.
Well, and I don't know either. There was an allegation that there were two different types of scales found in connection with that. One that can measure ounce amounts and one that can measure pounds. Which again doesn't mean that he was selling marijuana, but it brings concern. I'm going to set bond in this case. I'm going to set $20,000 for the possession with intent to distribute marijuana, $10,000 for each of the destructive device charges. So that'll be a total bond of $50,000 in addition to what amount I said yesterday.
Yes, sir. Thank you, Your Honor.
Okay. All right. Is there anything else, Mr. Florio?
No, Your Honor. I'll be in contact with his family. Mr. Borley, I'll come see you this afternoon to discuss this with you.
Yes, thank you.
Okay.
Thank you.
You're free to go back,
Thank you.
Mr. Borley, and you're excused, Mr. Florio.
Thank you, Your Honor. As always, it was good to see you, Judge.
Yes, sir. Okay, let's try to get back on track.
Your Honor, can we skip to Mr. Pierce?
Yes, sir. Mr. Pierce. Sir, you're charged with one count of criminal trespass. Bond is going to be set at $1,000. One count of obstruction. These are all misdemeanor offenses. Bond is going to be set at $2,000 for the obstruction. One count of a misdemeanor terroristic threat. Bond is going to be set at $4,000, and one count of disorderly conduct. Bond is going to be set at $1,500. You're going to have a preliminary hearing date set for January 3rd at 8:30 in the morning. That date will get waived upon your bonding out, and you receive a new court date in the mail. Do you want me to see if you qualify for the appointment of a lawyer?
Do I have like I'm gonna be able to get out today?
Yes, sir.
So if I'm saying if I don't bond out, I gotta stay locked up until January.
If you don't post bond, you don't get out.
I gotta stay here to my preliminary.
Or you can post bond and get out.
But you're not letting me sign my own bond.
No, sir.
All right.
Do you want me to see if you qualify for the appointment of a lawyer?
You gave me a surety bond or a signature bond?
Okay. You're gonna have three ways to post your bond. You can pay the entire amount in cash. Sheriff's office holds that and return it when your case is over. You can go through a bonding company where you pay a percentage of the bond. They keep whatever fee they charge. Or if you have property that has a net equity of at least 3 times the bond amount, you can post that. They'll put a lien on the property, and then when your case is over, they'll take the lien off. Okay. Now, do you want me to see if you qualify for the appointment of a lawyer?
I was just trying to make sure like if no money was coming out of my pocket, I'm not getting out of here at all. That's what you're saying, right? If no money is coming out of my pocket, I'm not getting out. That's what you're saying.
Well, it doesn't have to come out of your pocket, but a bond will have to be posted.
I'm saying the terminology, because that is different. Because
Your Honor, you can give him his court date.
is it a signature bond? Is it a signature bond? Like
No, it's not. No, it's not. You're gonna have to pay something.
Okay, that's what I'm saying. That's all I was saying.
Okay. All right, sir. I'm going to appoint a lawyer to represent you, Mr. Pearson. You can accept that lawyer, or you can fire that lawyer. You can do whatever you want to do. Okay?
Yeah.
All right, sir. You're free to go.
Thank you, Your Honor.
You're welcome. Okay, let's try to get, at least for me to be able to tell the entire group.
Y'all stand up, check out.
Okay, can we turn the camera on? Thank you. So, everyone, this is your first appearance hearing before the Magistrate Court of Clayton County. My name is Brad Gardner, and I'm a judge in this court. I am here to inform you of the charges that have been filed against you, to advise you of certain rights, to set bail on those offenses that I'm authorized to set bail, to schedule a preliminary hearing, and to determine whether you require the assistance of an attorney. You have the right to remain silent and say nothing, but should you give up this right, anything you say during this proceeding may be used against you. So please don't discuss the facts of your case. During this and all other proceedings, you have the following rights: to the presumption of innocence, to indictment by a grand jury for most felonies or by accusation for misdemeanors, to a speedy and public trial by jury, to see, hear, and question witnesses who are called to testify against you, to compel the attendance of witnesses to testify on your behalf, to testify on your own behalf or offer evidence in your own defense, and to have an attorney represent you. If you cannot afford an attorney, one can be appointed to represent you if you qualify. Some of you will be allowed to post unrestricted bonds for release from jail. These bonds may be posted by cash, commercial, or property. Some of you will have special conditions on your bond that prohibit you from contacting certain people or going to certain places. You will also be prohibited from contacting the victim while you are in jail. If you violate the court's order, your bond will be revoked and you can remain in jail until your trial. You could also receive additional felony charges. It is important to note that if someone is listed as a victim in your case, that person would not be allowed to post your bond. Some of you are charged with offenses for which this court is not authorized by law to set bail. In this event, a bond hearing will be scheduled before a judge of the Superior Court of Clayton County, and you will be informed of that date. If you are currently on active probation, this court is not authorized to set bond at this time. Where the bond is appropriate in your case will be reconsidered after your probation officer has had an opportunity to consider this new arrest. The purpose of a preliminary hearing is to determine whether there is sufficient evidence to support the allegations against you. The standard at this stage is very low. A judge determining whether a charge goes forward at this stage only has to determine that it is possible that the crime occurred. Everyone has the ability to waive their right to a preliminary hearing. However, you should speak to a lawyer first if you are unsure about whether it is appropriate to waive your preliminary hearing. If you post bond, your preliminary hearing is automatically waived. You'll receive notice at the address you give of your next court date. Lastly, would everyone please raise your right hand for me, please? Do you swear affirm any statements you make during this proceeding shall be the truth, the whole truth, so help you God? Okay, let's start on the ladies' side with Miss, is it Bowie? Bouie.
Come on up.
Good morning, ma'am. You're charged with one count of simple possession of a controlled substance, This is a felony offense. Bond is going to be set at $3,000. You're also charged with one count of loitering or prowling. Bond is going to be set at $1,000. Because of the felony, you're going to have a preliminary hearing date set for January 4th at 8:30 in the morning. That date will get waived upon your bonding out, and you receive a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
What?
Would you like for me to appoint a lawyer to represent you? No?
I mean, I don't think that it should be one represent for that. It's just something that I just need to just take care of.
So the answer is no.
I mean,
I have to have an answer from you, ma'am. I mean, you don't have to have a lawyer, but if you want a lawyer, I'll appoint a lawyer. If you don't, I'll let you do whatever you want to do.
I'll take a lawyer, sir.
I'm sorry.
A lawyer, sir.
It sounded like you said you don't want a lawyer.
At first I didn't, but then I don't even know thing of first offense of anything. I've never been in jail or nothing like that before, sir. So I don't even know how this works.
Okay, I'll appoint a lawyer to represent you. Do you have any questions for me, ma'am?
No, sir.
Okay, ma'am, you're free to go back. Miss Karstens?
Amanda Karsten.
Ma'am, you're charged with one count of theft by receiving stolen property, being in possession of a vehicle. I've set bond at $7,000 for that. You're also charged with one count of giving a false name, address, or date of birth, and I've set a bond at $2,000. Because of the felony offense, you're going to have a preliminary hearing date set for January 4th at 8:30 in the morning. That date will get waived upon your bonding out, and you'll receive a new court date in the mail. Do you want me to see if you qualify for the appointment of a lawyer?
Yes, please, that's fine.
Okay, I'm going to find you qualify, ma'am. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
So it's 7,000 and 2,000?
Yes, ma'am.
Okay, all right, thank you so much.
Okay, you're free to go back. Miss Rivera?
Whitney Marie Rivera.
Ma'am, you're charged with one count of battery. This is a misdemeanor offense. I'm going to set the bond at $5,000, but there's going to be a stay away provision on the bond to stay away from an Edwin Sanchez. Do you understand that, ma'am? I'm sorry, ma'am.
Yes, I do.
Okay. Your preliminary hearing date is going to be set for January 3rd at 8:30 in the morning. That date will get waived upon your bonding out, and you receive a new court date in the mail. Do you want me to see if you qualify for the appointment of a lawyer?
Yes.
I'm going to find you qualify, ma'am. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
No.
Okay. You're free to go back, ma'am. Can we bring up Miss Adams and Miss Jackson? And on the male side, can we bring up Mr. Gordon? And I think that's the only fugitive we have on the male side.
Yes.
Okay. Miss Adams, Miss Jackson, and Mr. Gordon, I bring you all up at the same time because you're all being charged with the same offense, which is fugitive from justice. And what that basically means is that there is a warrant for your arrest in another state. Miss Adams, you're wanted out of Chattanooga, Tennessee, for a charge of larceny. Miss Jackson, you're wanted out of the Polk County Sheriff's Office in Iowa, also for larceny. Mr. Gordon, you are wanted out of Jefferson County Sheriff's Office in Alabama, and the charge that you're charged with is murder there. So each of you have the right to have a hearing to determine essentially whether you're the person named in the warrant, and whether the warrant actually names a charge. That's all the hearing is going to be about. State of Georgia, Clayton County, we have no interest in whether you're innocent or guilty of these alleged offenses. Our duty is to hold you for them to come and pick you up. If you were to request a hearing sometime between now and the next 90 days, a hearing will be held to determine those two things that I told you. If the judge at that point determines that you are the person named in the warrant and the warrant does state a charge, the judge will sign off on your being extradited, meaning sent back to whatever jurisdiction that is requesting you. That will, if the judge signs that, the clock will start running at that point, and the requesting jurisdiction will have 60 days, 30 to up to 60 days to come and get you. If they don't come and get you at the expiration of that time, you will be released. However, the warrant will not go away. So if you're released out the front door and you encounter a law enforcement officer within 5 minutes and they run your information, they see that there is a valid warrant, this process starts all over again. So it's going to be in each of your best interests to deal with these charges. And it's probably, if you don't have a lawyer, it'll be in your best interest to get a lawyer out of in Tennessee, Iowa, and Alabama. So I'm going to start with you, Ms. Adams. Do you have any questions?
No, sir.
Do you know what you want to do?
I want to sign the paperwork so I can go.
Okay. You sign the paperwork, they'll send it to me, and then that clock starts to run today. Ms. Jackson, do you have any questions?
Questions that I'm also signing.
Okay. So once Ms. Jackson and Ms. Adams sign, they can be released back. Mr. Gordon, do you have any questions?
Yes, I do, Your Honor. Monday and yesterday, I spoke to my attorney in Birmingham, Alabama, with Keisha House. This is the third time that this has happened with me, with this extradition situation with this same. And she told me to ask two questions. This is the third time I went to magistrate courts about this situation. Once she told me to ask and said, I have a right, I'm trying, no disrespect to you, I have a right to have the warrant read to say of the deceased because it's an NCIC error in this. And what I'm saying, I want to waive extradition. This is the third time in 3 different jurisdictions I went through this. And she said to ask the judge today to read out the alleged person that's deceased. The reason why I'm saying this is we spoke to the Jefferson County's clerk of court and the district attorney's office, and they're saying they don't have no warrant for me for a murder, for the charge of murder. And I want to waive extradition. The second question I have is, when I waive this, what time does the clock, what day, how long does it take for them to come and get me? At what point will y'all release me if they don't come? And the reason why I asked, I know you say 30 to 60 days. I've been held 45 days for this one time and 6 months for this during the COVID and was released. This is the third time this has happened, Your Honor. And they have not said the warrant for a murder, who's the person deceased? And I just have those questions. I'm sorry to take up your time, sir.
No, sir. I asked if you have a question for that reason.
Yes.
So I have the warrant number. I don't have the warrant, the actual warrant.
And the reason why I asked that, because she told me, that's what I heard the 3 other previous times. And I'm asking, they say I have a right at this, in front of the magistrate court, to have the warrant read out to me. They say I have that right. If I have a warrant on me, and it should be attached with the NCIC and GCIC fugitive arrest warrant. That's what I just wanted to read. If I have, who is the deceased? Is it, and if not, can we come back and revisit? Can you set a court date if I sign this waiver to revisit this in a timely manner so I won't languish in jail for the 4th time for a warrant that's not even there?
Okay, are you ready for the warrant number?
I have the warrant number, actually, Your Honor. Warrant number that we have is 2022 WA 19033.
That's not what I have.
So that's what they have on this right here on the paper. The way
I have,
that's the one right there.
no, sir.
Yeah, the expedition number is, yeah.
Listen, Mr. Go ahead, sir. I'm sorry.
It's 2022 WA 19033.
That is the that's the docket number that brings you before me here. What I have, listen to me.
Yes, sir.
Okay. In that said offender did enter and remain in the state of Georgia, knowing he was wanted by Jefferson County Sheriff's Office, Alabama, for murder. Warrant number W440166322, a felony they will extradite. So when you are picked up on this, the first thing that the fugitive squad does is they try to verify the information. They contact what is called the requesting jurisdiction. And in this case, that's the state of Alabama, Jefferson County Sheriff's Office. They ask, do you have a valid warrant for Kirk Gordon? The answer that they will receive is either yes or no. If they received a yes and they're told that Alabama will come and extradite you, that ends that discussion.
Yes, sir.
And that's why I say we don't have any interest in whether you are guilty or innocent. That's why we bring you up, inform you of what's going on. You should be able to contact your lawyer, give her that number I just gave you, and she should be able to contact Jefferson County Sheriff's Office. Listen to me, just stand by.
Yes, sir.
Contact Jefferson County Sheriff's Office and say, hey, my client is being held in the Clayton County Sheriff's Department on this warrant number. Do you have this active in your system? They're going to say yes or no. If they say no, she then should go to a judge in Alabama, Jefferson County, have that judge sign off on a bond. Listen. They will then send that information to us and say, cut him loose. So I've had people that appeared before me on a Wednesday. They did what I just told you to do. They came back before me on Friday and they were released. So we're not the ones holding you. We're holding you for the Jefferson County Sheriff's Office in Alabama on this warrant number. So if it's an error in their system, they're the ones that need to fix it. Does that make sense to you?
Yes, the question I have, what you just stated, this is the exactly what you're saying is this happened. This is the 4th time. The question I'm asking you is, at what point will they come and say that? Because at the desk up front, when they fingerprinted me today, they stated that The sheriff's department of Clayton County was supposed to contact them. They showed me a copy of the warrant and said the contact were ready for pickup. The contact them ready for pickup. This is the fourth time. This is the third. I went to 3 different agencies over the last 2 years for this. When I'm asking you, when I signed this waiver, at what point, if nobody has came and gotten me, is somebody going to say something? This is reoccurring. This is an NCIC. This is a National Criminal Information Center. This is what my lawyer, I spoke to her. She spoke to the district attorney. I'm asking you, Your Honor, is there any way possible that you can set a time that I can come back? If I'm sitting here 2 months, 3 months, 45 days, and they haven't done it, and they haven't done their jobs because somehow somebody's not doing their job. I'm not trying to be difficult. I'm going by it's errors, and I'm the only one being punished. I'm being punished. Is that possible?
Let me ask you this question.
Yes, Your Honor.
Why didn't you sue the pants off of them the first time?
Because they violated my probation because of that. And then they found out, you know how they do the petition for probation? They found out, well, it wasn't, but I sat in the county, I've been here 60 days. 60 days, they've been in the probation court. Same thing in Fulton County, I sat there 5 months. Same thing, we don't have a warrant for them. So I haven't been out to even get legal counsel. That's why my lawyer told me to ask the judge today if they can get somebody in, bring me back in a certain amount of time. And if they have a valid warrant for me, I'm just languishing in jail. They're saying 60 to 30 to 90 days.
So
that's what this is.
Listen to what I'm telling you. Okay.
Yes, sir.
If this is a mistake, your lawyer can send something up here today showing that it is a mistake, and we will release you. Because guess what, sir? When you're here, we're paying to feed you, clothe you, keep you safe. We're paying for all of that stuff. But I bring you back every day, and I do not have any information from the Jefferson County Sheriff's Office saying that this warrant is not valid. I can see you every day, and the same thing's going to happen.
Exactly what you're saying. She's not licensed to practice. She's called up here. She called she called Patrick Labatt in Fulton County. That's how I was released from there. I had a hearing Monday before Judge Carter.
So listen, and I'm sorry for cutting you off because I got other people to deal with. But I'm trying to answer what you need to have answered to move you on. The person in Alabama, when I got the order from Tampa saying release that person, signed by the judge, filed by the judge in Tampa, I released the person. So ain't no calling anybody. All she got to do is do her job, which is to get the paperwork, get it signed, authorized, sent up here, and you will be released. What's so hard about that?
We've done that. What I'm saying is they haven't called. The sheriff department has not notified them that I'm ready for pickup. Every time they call up here, they said I'm still in custody. I'm ready. What I'm saying, y'all, I'm not trying to be disrespectful. The sheriff department of Clayton County is supposed to call them and say ready for pickup. They have not done that. They didn't do it in full. We had to do all that in full. They're not calling the agencies with the whole. Can you just put an order in them from the call and let them know that I'm ready for pickup? I'll sign a waiver right now. Are you ready to sign it?
So this is the process of how that works.
Yes.
If you sign that paperwork today, it comes to me. I send everything back. It gets entered into the system, and the fugitive squad will call down. Now, fugitive squad calls down. They don't take you down there.
I know they come.
It's their job to come and pick you up. So what I tell people, if you have a lawyer you can work both ends of the system at the same time. Your lawyer can say, hey, he signed a waiver. Y'all got to go get him. And oh, by the way, this is wrong. Okay. Now, does that make sense to you? And I understand. And let me restate what I believe you're telling me, just so I'm clear.
Yes, sir.
You're saying that the problem has been, at least this is the third time that this has happened. Fourth time, you can't find the warrant in the system. If that is the case, you have the ability to sue the pants off of everybody. If you don't take that step, then I can't, force you to do anything. But I'm looking just at your, okay. So it says here that the offense date was September 11th of 2020. And it's the Jefferson County Sheriff's Department and the Birmingham Police Department that have entered this record into your criminal history. It also shows stuff from other jurisdictions related to you. So you got something out of Columbus, Ohio. There's a misdemeanor assault from March 9th of 2007.
I was in prison in Georgia. I was at Tailfield State Prison.
Well, are you and I clear on what's holding you here?
A murder charge from the state of Alabama.
Yes, sir.
Of Jefferson County, Alabama. They said
Yes,
2000 September, I committed a murder. It's no murder. They've never, the warrant, they saying there's no deceased. And according to Georgia law, I have a right to have the warrant read out to me. Is nobody deceased? Who is deceased? Nobody. It's not a person deceased. And I'm not trying to be difficult. That's why I asked you, Your Honor. I was respectfully asking you, could you bring, if I'm here 30 days from now, could you at least bring me back, set a court, so I can revisit this? So if I'm sitting there language, and I'd be like, I told you, Your Honor, can you at least do that for me? So I won't language over and over for no reason. If it's a murder, they're gonna come and get somebody. If it's a murder, and I already signed the waiver, they're gonna come and get me. Think about it.
Let me ask you this question. Yes,
sir.
You keep telling me that there's no warrant in the state of Alabama
For no murder.
So why you just can't deal with that today and get out?
I signed the waiver. This is the fourth time I've signed the waiver for extradition. What I'm saying is, if they don't, who's gonna come and get me if there's no warrant for murder? If I'm not trying to get.
If there's no warrant for murder, show us. Well, she should show them. No, stop. The process is she shows them, they agree, then they contact us and say, release him, and you will be released.
What I'm saying, Your Honor.
So why you gotta wait 30 days? If there's no warrant, if there's no warrant for your.
They won't call and tell them I'm ready for pickup. The agency here will not call. Clayton County Jail will not call them and say, you ready for pickup.
Mr. Gordon, if there's no warrant for murder and you're being held here on the murder, either we wait for the state of Alabama to come and get you, or your lawyer gets off her behind, walk down to the goddamn courthouse and get proof. And she can do that today and you will be out today. So why are we talking about 30 days?
If I'm here 30 days from now, will you at least bring me back? Can you at least do that?
No. Why? Why? Why
That's
you
not-
just can't show that you?
This is no warrant. It's not a
Sir,
warrant.
go take a seat. Go take a seat. Go take a seat. Go take a seat, sir. Go take a seat.
Oh my goodness. Let me ask this question. Was I being unclear?
No, you're being 100% clear. He just wants to argue it. He just wants to argue it.
Okay. Now we got some other issues. Do you have two Aaron Bells there? An Aaron Bell Jr. and Aaron Bell Sr.? Somehow I only have one bond order, but it places I got two warrants for Aaron Bell Sr.
Give me 1 second, Judge. Give me 1 second, Judge.
Your Honor, we're good to go.
No problem. So I'm gonna have to do two separate warrants because somehow they put all of the charges for both Aaron Bells on one order. So for Aaron Bell Jr., I have two charges, two warrants, and for Aaron Bell, I have two warrants.
Come on, step up here, gentlemen. Step up here, gentlemen.
Okay. I'm gonna deal with Aaron Bell. I'll say senior first. Mr. Bell, sir, you're charged with one count of tampering with evidence, and that's a felony offense. I'm gonna set bond at $5,000. And you're also charged with one count of possession of a firearm by a convicted felon. And I'm going to set a bond of $5,000. And Miss Wesley, can you hear me?
Yes, Judge.
So in order to try to keep down confusion, the Aaron Bell that I just referenced, his warrant numbers are 2022 CW 55556. So 4 5s and 1 6.
Okay.
And that's tampering with evidence. For the possession of firearm by a convicted felon, as warrant number 2022 CW 55557. And I don't know if that's reflected on your calendar or not.
Yeah, it's only one on the calendar.
Okay. For Aaron Bell Jr., sir, you're charged with one count of murder. And
No, I'm junior.
Tell the judge.
My son is the third. I am junior where you said senior.
okay. So on this warrant, it has Aaron Bell, and those are the ones that I just read out. And then it's Aaron Bell that I am dealing with now. And on both warrants, it just says Aaron Bell. On the order for bond, it says Aaron Bell Jr. So I'll make sure that I reflect that the Aaron Bell who is charged with murder is Aaron Bell III. That's correct?
Yes.
Okay. Now, I cannot set bond for this offense at this stage. So on the murder, which again, Ms. Wesley, is 2022 CW 5550, bond is going to be denied pursuant to Georgia statute 17-6-1. You're also charged with it's like it says use of communication facility and commission of a felony involving controlled substances. And that's a felony charge, and the warrant number is 2022 CW 55551. So bond is going to be denied on that, and I'm just going to let the next judge deal with both of these charges. Mr. Aaron Bell Jr., sir, you're going to have a preliminary hearing date set for January 4th at 8:30 in the morning. That date will get waived upon your bonding out, and you'll receive a new court date in the mail. Do you want me to see if you qualify for the appointment of a lawyer? You say yes. I'm going to appoint a lawyer to represent you. Now, Aaron Bell Jr., do you have any questions about what I just read to you?
Yes, sir.
Okay. Now, Aaron Bell III, you're going to have a preliminary hearing date set for January 4th at 8:30 in the morning. I can't set a bond hearing date for you because this offense carries the possibility of life. Do you want me to appoint a lawyer to represent you?
I got one.
Okay. Tell your lawyer that the lawyer is going to have to file a bond motion in the Superior Court of Clayton County. And the way that they do it is one judge presides over these hearings every month, then they rotate. So I believe Judge Mason may be the presiding judge now. So if your lawyer is on the ball, your lawyer may be able to get you a bond hearing relatively quick. They happen on Fridays, and the holidays are coming up, so that may impact when the hearing is actually held. Do you have any questions for me, Mr. Aaron Bell III?
No, sir.
Okay. All right. The two of you are both free to go back.
All right, thank you, sir. Thank you.
You're welcome. Mr. Calloway.
Sir.
Mr. Calloway, sir, you're charged with 1 count of aggravated assault and 1 count of possession of firearm by a convicted felon. Bond is going to be denied on these 2 offenses at this stage. There's going to be a stay away provision on your bond, a stay away from Cindy Calloway. Do you understand that?
Sure.
Your preliminary hearing date will be set for January 4th at 8:30 in the morning. I'm going to also set a bond hearing date for January 6th at 8:30 in the morning. Do you want me to see if you qualify for the appointment of a lawyer? Okay, I'm going to find that you qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
Yes, sir.
Okay. Mr. Connolly. Mr. Connolly, sir, you're charged with 1 count of battery. This is a misdemeanor offense. Bond is going to be set at $5,000. There's going to be a stay away provision on your bond to stay away from a Archivia Benz. Do you understand that, sir?
I understand, but that's a false report. They said the wrong thing. Really? Okay.
Do you want me to appoint a lawyer to represent you?
Yes.
Okay, I'm going to appoint a lawyer to represent you. You're going to have a preliminary hearing date set for January 3rd. That date will get waived upon your bonding out, and you'll receive a new court date in the mail. Now, everything that you're about to tell me, that's what you tell your lawyer, okay?
Okay.
Thank you, sir. You're free to go back. Mr. Diaz.
Yes.
He's coming, Judge.
Okay, Miss Wesley, I got a notice that Mr. Jesus Pena needs a Spanish interpreter. Do you believe you can send a message to see if anyone is available?
Sure, Judge. Who was that for again?
Last name is Pena, Pina. First name is Jesus.
All right, I'll try to reach out.
Okay, and in the on the bond order it says Jesus Pina Sanchez. Mr. Diaz, sir, you're charged with 1 count of battery. This is a misdemeanor offense. Bond is going to be set at $5,000. There's going to be a stay away provision on this bond to stay away from a Jennifer Pruitt. Do you understand that, sir?
Yes, sir.
Your preliminary hearing date is set for January 3rd at 8:30 in the morning. That date will get waived upon your bonding out, and you'll receive a new court date in the mail. Do you want me to see if you qualify for the appointment of a lawyer?
Excuse me, somebody's talking. I have sensitive ears. I apologize.
No problem. Do you want me to see if you qualify for the appointment of a lawyer?
No, I don't need any lawyer.
Okay. All right, sir, you're free to go back. Mr. Dyer. I'm sorry?
Am I allowed to get an OR to be taken to a mental hospital?
I'm not going to set an OR bond, but if you need to have that consideration, you should really let me appoint a lawyer, because the lawyer can do a consent bond that'll have you transported to the place that it appears that you want to go.
First priority is paying the bond, which comes next month. My mother has access to my team checking account, which I kept held in just in case things like this happen. I really didn't want to happen. So,
Okay.
Yeah, if you can let my mom know about the bond, she can take out the money and all that. They can do whatever with it. It doesn't matter. It's just I have plenty of time on my hands, you know. So like, yeah, that's the first priority. Second priority is, well, that's not a priority to go to the mental hospital. I just want that to be paid off. You know what I'm saying? Just in case.
Okay. Anything else, sir?
No, sir.
So what's going to happen is that when all of this is over, I prepare the paperwork and I send it back to the sheriff's department, and they input all of the information into the system. So if you were to speak to your mother, and if she was going to use a bonding company, the bonding company would know everything about your bond. Okay. All right, sir, you're free to go back. Mr. Dyer? Mr. Dyer, sir, you're charged with 3 counts of violation of Georgia Controlled Substance Act. And these are felony offenses. Bond is going to be denied at this point on those 3 felony charges. You're going to have a bond set for the use or possession of drug-related objects at $1,500, and loitering or prowling bond is going to be set at $1,000. Your preliminary hearing date is going to be set for January 4th at 8:30 in the morning. You're going to also have a bond hearing date set for January 6th at 8:30 in the morning. Do you want me to see if you qualify for the appointment of a lawyer?
Yes.
I'm going to find you qualify, sir. I'm going to appoint a lawyer to represent you. Okay, sir, you're free to go back. Mr. Kornicki. Mr. Kornicki, sir, you're charged with one count of driving a vehicle while unlicensed, and you're also charged with one count of possession of a firearm. And they call it the illegal transfer of a firearm. I'm going to set a bond at $7,000 for that. Your preliminary hearing date is going to be set for January 4th at 8:30 in the morning. The date will get waived upon your bonding out, and you'll receive a new court date in the mail. Do you have any questions for me, sir?
So basically just my bond is 7,000, sir?
8,000.
8,000?
Yes, sir.
Okay.
All right. Is there anything else?
No, sir. Happy holidays.
You too. You're free to go back. Mr. Is it Long Gepi? Long Gupe. I apologize, sir.
All right.
Give me 1 second, sir. Oh boy. Sir, you're charged with one count of simple battery. This is misdemeanor offense bond is going to be set at $4,000. There's going to be a stay away provision on the bond to stay away from a Russell Gruber. Do you understand that, sir?
I'm not sure. I've got some background noise over here. I can't make out what you're saying.
Okay.
My bond is $4,000 in.
Yes, sir.
Russell Gruber.
Yes, it's a stay away provision for a Russell Gruber.
Wait.
I'm sorry, sir.
A stay away provision? I don't know what that is.
That means that you're to stay away from Mr. Gruber.
Okay.
This condition can be changed, but it'll have to go through the Solicitor General's office. They'll look into it and they can ask the court to modify the condition. We just don't want whatever led to you appearing before me today to flare back up this evening. Okay.
Right. Yes, sir.
All right, sir. Do you want me to see if you qualify for the appointment of a lawyer? Did you say yes?
Yes, please.
Okay. I'm going to appoint a lawyer to represent you. Your preliminary hearing date is going to be set for January 3rd at 8:30 in the morning. That date will get waived upon your bonding out, and you'll receive a new court date in the mail. Okay, sir. You're free to go back.
All right. Thank you, sir.
You're welcome. Mr. Lyons? Mr. Lyons, you're charged with one count of theft by deception. This is a misdemeanor offense. Bond is set at $2,000. You're going to have a preliminary hearing date set for January 3rd at 8:30 in the morning. That date will get waived upon your bonding out, and you'll receive a new court date in the mail. Do you want me to see if you qualify for the appointment of a lawyer?
Sure.
Okay.
Yes.
I'm going to find that you qualify. And I'm going to appoint a lawyer to represent you. You're free to go back. Mr. McClendon. Mr. McClendon, sir, you're charged with 2 counts of violation, Georgia Controlled Substance Act, possession of more than an ounce of marijuana, and possession with intent to distribute marijuana. I'm going to set bonds of $10,000 on each of those counts. You're also charged with 1 count of possession of a firearm during a felony. I'm setting a bond at $5,000, and you're charged with 1 count of essentially driving a vehicle with a cracked windshield, and bond set at $500. Because of these felony offenses, you're going to have a preliminary hearing date set for January 4th, at 8:30 in the morning. That date will get waived upon your bonding out, and you'll receive a new court date in the mail. Do you want me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Okay. I'm going to find that you qualify. I'm going to appoint a lawyer to represent you. You're free to go back.
Appreciate it.
Okay, Miss Kelly? Sir, you're charged with 1 count of possession of firearm by a convicted felon. I'm setting the bond at $10,000. You're also charged with violation of Georgia Controlled Substance Act with possession of methamphetamine. That's also a felony. Bond is going to be set at $10,000. You're charged with use or possession of a drug-related object. That's a misdemeanor. Bond is going to be set at $1,500. And you're charged with possession of firearm during the commission of a crime. And I'm going to set the bond at $2,000.
Question.
Yes.
I'm not a felon. I know it's said not to talk about it, but I was charged, but I wasn't convicted. And I'm not sure how that makes me a felon. I wouldn't.
Hold on. Hold on. Let me take a look.
Yeah.
Sorry, it's a number of documents I got to go through.
That's in question. If I received a stolen property.
I'm sorry, sir.
It was the one in Ohio. That's, if that'll help, that's the one that's in question. It's a charge of theft by receiving stolen property. That's the felony that's in question. It's charged, but I wasn't convicted.
Okay. Says there's a warrant for your arrest out of Youngstown, Ohio. I don't know if you knew that.
Yes, I do. It's a non-extraditable warrant, and that's what this is in reference to. But I have to get up there myself to handle that because they're not going to come get me.
Okay. So I'm going through, it says that you have 29 cycles. And a cycle is every time that you interact with the police. I'm sorry?
No, that was the officer.
Okay. Hmm.
So, I'm just kidding.
Hmm. Okay, so it looks like it's something out of Cobb County Superior Court from looks like April of 2011. I think that's the thing that's popping up.
Cobb County. I haven't heard of that.
Okay, sir.
I haven't heard of the Cobb County case in a while. I hadn't heard that pop up. No one told me that popped up. They just told me that Ohio was what's popping up. This is my first hearing about Cobb County.
There's something out of the Superior Court of Cobb County.
For can I ask what's charges? Is that no?
It's showing up as some kind of probation violation out of Cobb County Superior Court.
All of my probation cases have been settled through time served.
I mean, that's what's showing. It's not showing as being on probation. It's showing that it was reported out of the Superior Court of Cobb County.
Again, upon my release, I can dig into it. I'm actually in the process of getting all those old open sort of cases closed. So this is a total other mix up. But yeah, I haven't heard of Cobb County in a minute though.
Okay. Okay. Anything else, Mr.?
No, that's it.
Oh, let me ask you if well, you're gonna have a preliminary hearing date set for January 4th at 8:30 in the morning. That date will get waived upon your bonding out, and you'll receive a new court date in the mail. Do you want me to appoint a lawyer to represent you?
Yes, Your Honor.
Okay. I'm gonna appoint a lawyer to represent you. Is there anything else, Mr. Muskelly?
What is the bond in my skin, or will I get something paper to show me?
I'm sorry, sir.
Can I get the bond amounts again?
Total amount is $23,500.
Okay.
Okay, sir. You're free to go back. Mr. O'Bannon? Mr. O'Bannon, sir, you're charged with 2 counts of violation of Georgia Controlled Substance Act, setting bond at $10,000 apiece for those charges. You're also charged with 1 count of possession of a firearm during the commission of a felony. I've set the bond at $10,000. You're charged with use or possession of drug-related objects as a misdemeanor. I've set the bond at $1,500. You're charged with the third count of violation of Georgia Controlled Substance Act. I'm setting the bond at $10,000, and you're charged with one count of loitering or prowling. Bond is going to be set at $1,000. You're going to have a preliminary hearing date set for January 4th at 8:30 in the morning. That date will get waived upon bonding out, and you'll receive a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer? I'm going to find you qualified, Mr. O'Bannon. I'm going to appoint a lawyer to represent you. Is there anything else, sir?
What was the total bond amount, sir?
$42,500. Okay. Mr. Primus.
Yes.
You're charged with one count of possession with the intent to distribute marijuana. I'm going to set a bond of $10,000 for this offense. You're going to have a preliminary hearing date set for January 4th at 8:30 in the morning. That date will get waived upon your bonding out. Do you want me to see if you qualify for the appointment of a lawyer?
Yes, Your Honor.
I'm going to find you qualify, Mr. Primus. I'm going to appoint a lawyer to represent you. Do you have any questions for me, sir?
No, Your Honor. Thank you. Have a good holiday.
You're welcome. Well, we're waiting on to see about Mr. Sanchez. If we don't have the interpreter, we may have to continue him until tomorrow.
Okay, that was the gentleman that we found at the last minute. That's what I was telling you about that we were trying to look for.
Okay. I mean,
you want me to just have him down here tomorrow morning?
I'm sorry.
You want me to have him down here tomorrow morning if we can't find one?
Yes, let's wait until we get to the end, but if not, we'll just have to bring him back tomorrow.
Yes, Your Honor.
Okay, Mr. Scott. Mr. Scott, you're charged with one count of criminal trespass, damage to property as a misdemeanor. I'm going to set the bond at $2,000. There's going to be a stay away provision on this bond to stay away from a Sylvia Scott. Do you understand that, sir?
Yes, sir. I just went to court for that yesterday.
Okay.
Matter of fact, it was Tammy Judge. She told me I was released in 2 days.
So you went to state court? Is that what you're saying?
Yes, I went I think state court, yeah. It was court here yesterday. It was court yesterday.
Okay.
Released in 2 days. It's already been a day, so tomorrow, probably Friday morning, I'll be released.
Okay. Well, for this, I'm going to set a $2,000 bond. I'm putting a stay away provision to stay away from Sylvia Scott. Do you understand that?
Yes, sir.
And if this was done in error, it'll get fixed. So you already have a lawyer?
I had 2 counts. I had one at another address. I had 2 counts, criminal trespass and 1 count versus first degree damage to property.
Okay.
Yeah. Judge, I was talking to the first time.
Okay. All right. Well, let me ask this question again. Do you already have a lawyer, or do you need me to appoint a lawyer for this case?
I already have a lawyer. His name is Justin Moore.
Okay, so that's with Lister and Hope.
Mhm.
I'm going to just mark here that I'm appointing a lawyer for this. And if it's the same thing or something similar, then I'm sure Mr. Moore can get it worked out.
All right, thank you.
You're welcome. Mr. Thomas.
Your Honor, I think if I'm right, Mr. Thomas has gotten OR bond. I could be wrong, but he is not here from what I spoke to ladies up front.
Okay. Okay.
I could be wrong, but that's what I was told by the clerks up front.
Okay. I'm gonna put on here that he was released. Do you have a Brian Williams?
Yeah, we have a Brian Williams, Your Honor.
Okay. Let's bring up Mr. Brian Williams. Sir, you're charged with driving a vehicle with no tail lights and possession of marijuana less than an ounce. These are two misdemeanor offenses. I'm going to set a bond of $500 on the no tail lights and a bond of $1,500 on the possession of marijuana less than an ounce. Your preliminary hearing date is going to be set for January 3rd at 8:30 in the morning. That date will get waived upon your bonding out, and you'll receive a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
No, I haven't.
Okay. Do you have any questions for me?
No, thank you. Thank you.
Okay, sir. You're free to go back. Mr. David Williams.
Is there Mr. David Williams?
I think Mr. David Williams is another one too. I'm at the check on those two, Judge, and give you email on those two. But I know one or two of them got OR bond, and they were out.
Okay. All right. So I'm going to put on here out to bond.
Yeah, I will give you an email after I find out, but I think that's what we were told down there by the clerks.
Okay. Mr. Worthen.
Here he comes, Your Honor.
Mr. Worthen, sir, you're charged with one count of possession of marijuana less than an ounce. That's a misdemeanor offense. Bond is set at $1,500. You're also charged with possession of a firearm by a convicted felon. I'm going to set a bond at $10,000 for that. And you're charged with possession of a firearm during the commission of a crime. I'm going to set a bond at $5,000. Because of these felony offenses, you're going to have a preliminary hearing date set for January 4th at 8:30 in the morning. That date will get waived upon your bonding out. And you receive a new court date in the mail. Do you have any questions of me?
Yes, sir. There's no firearm for convicted, so it wasn't never convicted.
It says that you're alleged to be a convicted felon from a conviction on November 12th of 2022 on a previous felony firearm and marijuana charge. So that's what they're alleging. If it's wrong, it can get fixed.
Okay.
Do you need me to appoint a lawyer to you?
Yes, I already signed the paperwork.
Okay, I'm gonna find that you qualify. Going to appoint a lawyer to represent you. Do you have any questions of me?
No, so what's the total amount per bond?
Let's see, $16,500. Okay, you're free to go back, sir.
Thank you.
So it looks like we're at the end except for Mr. Sanchez. And I'm inclined just to bring him back tomorrow.
Judge, how are you doing? Mr. Sanchez says he understands English, he just can't speak it, but he understands. That's what he is saying.
Okay. Well, bring him up if he
what he claims. Yes, sir.
Okay. Sir, you're charged with one count of family violence battery. Bond is going to be set at $5,000. There's going to be a stay away provision on this bond to stay away from a Sandra Bejarano Garcia. Your preliminary hearing date is going to be set for December 3rd at 8:30 in the morning. That date will get waived upon your bonding out, and you'll receive a new court date in the mail. I'm going to appoint a lawyer to represent you. And I'm sorry. Are you asking for the name of the lawyer?
I can't hear you.
Okay. I am going to appoint a lawyer to represent you.
Okay.
Okay. Now, do you have any other questions?
Yo no entiendo lo que me dice.
Tienes preguntas.
No, que si me van a dar bomba para salir. Le digo que sí. Yes.
Okay. All right, sir, you're free to go back.
Judge, I think you told him his date was December the 3rd. It's January the 3rd.
Oh, I'm sorry. It's January the 3rd. Okay. Thank you, Miss Wesley. Oh, man, this has been a tough.